Why is it fundamental to explain and distinguish between condition and warranties so that, and in nominate terms, there is a third terminology, in nominate term. What is in nominate term? It's a term which can neither be classified as a condition or a warranty, in which there is a confusion. You cannot be sure that whether it's a condition or it's a warranty. It might be a condition for someone, it might be a warranty for someone. It's such a term. Okay. Some clients might let go of it, some clients might say, no, we want it,
Yeah,
right? So it's
yeah,
and so those terms would be classified as in-nominate terms. Now, why is it fundamental to understand and distinguish between these three terminologies? Because so that the judges can decide whether it's a breach of contract, it's whether
yeah.
it's a breach of a condition, or is it a breach of a warranty, or is it a breach of an innominate term, because then the penalty and the penalization would be decided accordingly. Okay, please read the first point.
A condition is a vital term going to the root of the contract, breach of which entitles the injured party to decide to treat the contract as discharged and to claim damages. It's a
Hmm.
vital term. You have to follow it. If you have not followed it, that means you have to pay the damages now because you have not followed it. And warranty is a term subsidiary to the main purpose of the contract, be breach of which only entitles the injured party to claim damages. We can only just claim damage if it's a warranty, then court will later decide that what they need to do.
Right. Next. Okay, this all is done. Classification may depend upon the following issues as well. Okay, so please read what are the other issues.
Statute often identifies implied terms specifically as conditions or warranties. An example is the Consumer Right Act 2015.
All
It is
right.
often
Implied terms की
implied.
बात हो रही है. Implied terms means what? कि जो express,
Obvious.
they are not expressed
Expressed. Yeah.
orally or in written. They are understood. It is understood that if you're a citizen of Pakistan, you have to abide by the Constitution of Pakistan. Okay,
Yeah.
it is obvious. Now, statute makes it very clear in some of the laws कि कौन सी चीजें जो implied terms हैं वो कौन से ऐसे terms हैं कि जो condition की category में fall करेंगे और वो कौन से ऐसे terms हैं जो warranty की category में fall करेंगे. So state has made it very much clear in the law in the Consumer Rights Act 2015. It's just an example that in that in every act it is clearly mentioned whether it's a condition or a warranty. Next case.
Case law may also define particular type of clauses as conditions. For example, a clause as to date of expected readiness of a ship led to a character.
Charter.
Charter.
Charter. Okay. So the Hylas Angelus 1971. अब याद रखें हम UK law पढ़ रहे हैं and also we are studying UK law जो काफी मतलब when there was the only mode of transport for cargoes and for the things to be delivered from one place to another was by sea. Okay, so in those days, it was expected that okay, you have to, we know that how much time will the ship be ready in how much days, in how many days. So in that case, then there is a categorization that whether it's a condition or it's a warranty. ये सारी बातें केस लॉ में भी मौजूद है कहीं ना कहीं. नेक्स्ट.
The court may construe what was the intention of the parties at the time of the contract was made as to whether a broken term was to be condition or a warranty. Okay, now whenever the court is reviewing the contract, they just consider what their intentions were. Like when both parties were making up the contract, what their exact intentions were, and after looking at the intentions, just making sure of it, then later they decide whether it's a condition or a warranty.
Okay, and then this a very important last statement. Please read.
It is important to remember that if the injured party merely wants damages, there is no need to consider whether the term broken is a condition or a warranty, since either type of a breach entitles the injured party to damages.
What is the damage, Pinza?
Damage is monetary value, whatever monetary value we are paying.
Penalty in in terms, in monetary terms.
Yeah.
Now, what are they saying? What is the statement saying?
They're saying if the party, if one of the party is, merely wants
Mere,
damages,
merely wants.
merely wants means
यानी
doesn't want damage.
उसको सिर्फ और सिर्फ damages से मतलब है, उसको सिर्फ पैसे चाहिए.
मतलब है. हाँ, so अगर मतलब है, then they will no need to consider. Then there is no need to consider whether it was a condition or a warranty. Now, if I know the intention of the person, like there are some cases even nowadays going through media, and we see that okay, that person was actually just interested in money, not that person didn't have any relation with her spouse or anything like that. So, if the judge know that it was just that, then they will not consider this case.
Exactly. Now see, अब अगर आप यूके में रहते हो और आपको पता है कि आपके राइट्स हैं, कंज्यूमर राइट्स हैं, और आपकी सुनी जाएगी, और आप कभी भी किसी भी वक्त किसी को भी सू कर सकते हो और कोर्ट आपके हक में फैसला सुनाएगा, तो आप तो गाड़ी के कवर के लिए भी इशू बना लोगे.
Hmm.
आपको पैसे चाहिए नहीं. कॉन्ट्रैक्ट
Exactly.
में लिखा है कि सारी चीजें मिलेंगी. जब कॉन्ट्रैक्ट में लिखा
Hmm.
है तो लिखा है. आई डोंट केयर वेदर. अब हु नोज, अगर एक लेमैन की बात की जाए आज से पहले, कि आपको पता था कि कंडीशन और वारंटी दो अलग चीजें होती हैं?
नहीं,
नहीं.
बिल्कुल भी
क्योंकि
नहीं.
हम एसीसीए पढ़ रहे हैं, हम एक स्टूडेंट हैं, हम लॉ का प्रोफेशनली ये सब्जेक्ट पढ़ रहे हैं, इसलिए हम इन बातों को पढ़ रहे हैं. मगर आपको क्या लगता है कि लेमन, यूके के लेमन को भी इस तरह की बातें क्या इतनी डिटेल में पता होंगी? ये कंडीशन क्या है, वारंटी क्या है, नॉमिनेट टर्म्स क्या है? शायद मालूम हो, क्योंकि वहाँ लॉ बहुत प्रैक्टिस किया जाता है, अप्लाई होता
हम्म.
है, तो शायद मालूम हो. मगर किसी को, मतलब अगर मैं एक सिटीजन हूँ और मैं एक आम सी खातून हूँ, घर में रहती हूँ, मुझे क्या पता कंडीशन क्या है, वारंटी क्या है? मुझे तो अपने, मुझे इतना पता है कि मेरी बात सुनी जाएगी. मुझे इतना पता है मेरे
हम्म.
साथ कोई जाती होगी, मैं भाग के कोर्ट जा सकती हूँ. मुझे इतना पता है मैं हर बात पे सू कर सकती हूँ. और मुझे इतना पता है
हम्म.
कि गवर्नमेंट और कोर्ट जो है वो बहुत जस्टिस देता है, तो मैं अगर सही हूँ तो मुझे मेरा हक मिलेगा. ठीक है. तो आई कैन से दैट वाई I have children at home, and I have taken out, this precious time to come and pick up the car. And I want the cover with it because you have mentioned it in the contract. I don't care whether it's coming in 15 days or what not, or what was the problem behind the
Yeah,
scene.
or maybe you are leaving for some other city and later you cannot come back, like so.
The city, I need the cover.
Yeah,
Then I don't need the excuses. I need what I was promised.
yeah,
So I can sue. Not all customers would let it go, right?
exactly.
So that is it is okay. Next. In nominate terms, please read.
It may not be possible to determine whether a term is a condition or a warranty. Such terms are classified by the courts as innominate terms. Yeah, you have already told this before.
Done.
When there's a confusion is it's between condition and warranty, then it is called innominate terms.
What is an exclusion clause?
An exclusion clause may attempt to restrict one party's liability for breach of contract or for negligence.
Hmm. Exclusion clause क्या किसे कहते हैं, क्या होता है? Have you
May
ever
attempt to
come
restrict
across this?
one party's liability for breach. Restrict. Okay, it's like they are blaming one party, and now this one party, whoever is being blamed, is bound to pay the liability because of maybe breaching of the contract or maybe negligence. Like it happens in hospitals at times that the doctors they are sued and because they were neglecting some nurses, and so they have to pay the liability.
No. Exclusion clause is something which helps you escape liability.
Oh, okay.
Exclusion clauses are mentioned in the contracts, like you entered into a contract to get your surgery done. So there would be an exclusion clause that in case of death, in case of negligence, in case of any mishap that
Negligence from the other party or
any
from me.
they will use another words. They will say that in case of a mishap in during the surgery, we are not responsible. We are not liable. The hospital is not liable. And they get it signed by you. You sign it.
Okay. Okay.
Then you find
For
exclusion.
example, there's sometimes it happens if I'm booking a car, they just tell us before that, okay, we'll try to deliver it in 4 months, but in case we won't be able to deliver it, we are not bound. We'll just give you the money back.
They might put an exclusion clause in the contract. Even the banks do this. They do this very often. Banks,
Okay.
that the insurance companies, they do it. That in case it's an accident or something, or it's a natural calamity, we will not be responsible to pay you. Any kind of escape of liability, any party wants to put, they can use this exclusion clause. Okay. And once both parties are mutually agreeing to it and signing it, then there is no objection.
Okay.
Okay. Please read from here.
Uh, the court have generally sought to protect consumers from the harsher effect of exclusion clause in two ways. Exclusion clause must be incorporated into a contract before they have legal effect. Exclusion clause are interpreted strictly. This may prevent the application of the clause. From the second one, I think it says that if I have made any exclusion clause that I am excluded with this liability, then I have to make sure it is very visible. I have to make sure that I have interpreted it very nicely. It's not like I have written 100 terms and conditions. I'm just putting one of it, the exclusion clause. It's not that. We have to make sure it's properly visible and properly known by the other party.
Exactly.
And exclusion clause must be incorporated in a contract before they have legal effects. In a
Incorporated into
decide.
a contract means that before the parties sign, the exclusion clause
Okay,
must
okay.
be present. It shouldn't be कि अच्छा sign कर लिया party ने फिर बाद में आपने डाल दिया exclusion clause.
वो तो खैर कोई भी आप बाद में नहीं डाल सकते आफ्टर द सिग्नेचर.
डाल सकते हैं. आजकल फोटोशॉप आ गया, बहुत कुछ किया जा
हाँ,
सकता
वो तो फिर इलीगल है.
है, बहुत कुछ किया जा सकता है. So anyway, so that's what they say. And then exclusion clause are interpreted strictly. Definitely you can't just hide the meaning under the words by playing with the words. So you have to be very clear and precise. Okay, ji. Now what we have, incorporation of exclusion clauses. Please read.
The courts protect parties from the harsher effect of the exclusion clause by ensuring that they are properly incorporated into a contract and then by
Pretty
interpreting
strict.
them strictly.
यानी exclusion clauses के अगर कोई साइड इफेक्ट्स हैं, कोई ऐसी चीज है जिससे कंज्यूमर के राइट्स डिनाई हो रहे हैं, तो उसमें फिर स्टेट इंटरफेयर करती है, कोर्ट प्रोटेक्शन देती है और कुछ कायदे कानून बताती है. ठीक है. लाइक फॉर एग्जांपल, दे डू दिस, the law seeks to protect parties from the full force of exclusion clauses. They do this by applying the letter of the law to see if such clauses have been incorporated correctly. Where there is
Okay.
uncertainty, the clauses may be excluded from the contract. जहाँ थोड़ा सा भी
Okay.
अनसर्टेनिटी का जुमर में आता है या गुम की कैफियत है, क्लियरली टर्म्स एंड
Hmm.
कंडीशंस नहीं लिखे हुए, कुछ हिडन मीनिंग्स भी हैं उन वर्ड्स में, तो फौरन ही कोर्ट बोलता है कि भाई ये एक्स को एक्सक्लूड करो, ये चीज हम कंसिडरेशन में नहीं लाएंगे. ठीक.
Okay.
Such uncertainty can arise in several circumstances. Number one, the document containing notice of the clause must be an integral part of the contract. It shouldn't be like that कि contract इसमें sign करवा रहे हो और जो exclusion clause है वो एक छोटी सी मिनी कोई बुकलेट बना के इसके साथ अटैच कर दी. ऐसा नहीं हो
Mm-hmm.
सकता. It has to be in this. It has to be the integral part of this. Okay. Next,
Okay.
if the document is an integral part of the contract, a term may not usually be disputed if it is included in a document which a party has signed. अगर पार्टी ने साइन कर दिया है और वो इंटीग्रल पार्ट है कॉन्ट्रैक्ट का, वो पर्टिकुलर टर्म एक्सक्लूजन क्लॉज, तो फिर जब पार्टी ने साइन कर दिया तो फिर तो मुद्दा ही खत्म हो जाता है कि पार्टी ने अग्री
Hmm.
और वो इंटीग्रल पार्ट था. द टर्म मस्ट बी
Hmm.
पुट फॉरवर्ड बिफोर द कॉन्ट्रैक्ट इज मेड. वो टर्म एक्सक्लूजन क्लॉज पहले से वाजे क्लियर इंटरप्रिटेशन के साथ इनकॉर्पोरेशन के साथ सामने रखा जाए, तब जाके वो अगर
Hmm.
साइन कर रहे हैं तो इट्स ओके फाइन. इफ द कॉन्ट्रैक्ट इज नॉट साइंड, an exclusion clause is not binding term unless the party whose rights it restricts was made sufficiently aware of it at the time of agreement. Like for example,
Mm-hmm.
आपने वो वाली मूवी देखी है ओ माय गॉड. It's a
No.
movie in which Paresh Rawal is the actor, and it's a very interesting movie जिसमें वो यही दिखाते हैं कि भाई उस बंदे ने अपनी दुकान की इंश्योरेंस ली हुई थी, ठीक है, और वो हर महीने प्रीमियम भर रहा था. One fine day when he woke up, there was an earthquake and his shop was destroyed, completely
Mm-hmm.
destroyed. तो वो इंश्योरेंस कंपनी के पास जाता है कि भाई मैंने हर महीने तुम्हें पे किए है प्रीमियम, तो मुझे दो मेरे पैसे इंश्योरेंस के. मेरी दुकान देखो क्या हाल हो गया है, मैं तो सड़क पे आ गया हूँ. ठीक है, तो द इंश्योरेंस कंपनी सेज सॉरी सर, वी कैन नॉट पे यू. And that person gets so disturbed and frustrated and he's confused that why they are refusing to pay. So they bring the contract and they show the contract to him that, see sir, you have signed it yourself, there is an exclusion clause, and the exclusion clause states in a very tiny little fonts that uh, no that the insurance company is not liable if there is an act of God.
Okay.
So now how they have the words.
Exactly. They have covered their back. Yeah.
That's it. Now, he is saying that this is so weird, this is so absurd that I have been paying you for this day, that one day there can be a disaster when I won't have
Exactly.
enough money to support myself. Then this insurance company would give me a lump sum and I can, stand on my feet again.
Rebuild it. Yeah.
And it's my money that I've been paying you, and I'm asking for my money that I've been paying you for months, for years. And suddenly, when the day has arrived, you are refusing me for what? For this little exclusion clause that is not even visible with the naked eye.
Yeah.
And so he takes a stand for it. He goes to the
Mm-hmm.
court, he files a case, and nobody is willing to become the lawyer of his case. Nobody is willing to
Yeah.
take up the case. Why? Because he has signed that contract.
That's right.
So the case is so weak. Now this actor, this man, he takes a step that okay, there is मतलब he gets so इतना परेशान हो जाता है बेचारा, इतना upset हो जाता है. He tries to figure out a way to get back his money. And he then thinks that okay, let me see how can I do this? How can I turn the tables over? He becomes the lawyer for himself. And what he
Oh,
does, he plays in such a way that okay, you are saying that we would not pay you if this is act of God. And he tries to prove it that this is not act of God. Okay, this is act of human, because humans have constructed this way, and there is an earthquake.
okay, okay,
Not
okay.
the act of God. The God is not responsible because in the first place the movie also
Human actually built up the houses, so he is actually just converting his case there.
converting his case, and also he was a non-believer in God. Since the
Uh-huh.
beginning he was being shown as atheist and that he does not believe in God at all. And he belongs from a Hindu family, but he was born in a Hindu family, but he is also like say सब धंधा है ये सब खाली कारोबार है.
Uh.
Okay, so that's what, it's very interesting movie if you get time. His acting is awesome and the मुद्दा यही है सारा exclusion clause
Uh-huh.
के नाम पे how companies can abuse you, abuse
Exactly.
clients, the customers, and misuse their, refuse to give them their rights.
Mm-hmm.
Next, onerous terms. Onerous terms must be sufficiently highlighted. It is doubtful whether this applies to signed contracts. Now, what are onerous terms? Onerous terms is a one-sided contract.
Mm-hmm.
Okay, that means we are living in Karachi, we pay the electricity bill. Do we set the terms and conditions of the contract?
No.
It's the K Electric. They
Yeah.
written the terms and conditions for us,
Oh, okay.
and we just
Got it.
agree to it. There is no other choice.
Yeah.
Okay. Now, contractual documents, we know that where the exclusion clause is contained in an unsigned document, it must be shown that this document is an integral part of the contract and is one which could be expected to contain the terms. That means उसको बिल्कुल वाजे करो. Signed contracts, mm, unsigned contracts and notices. Each party must be aware of the contract's terms before or at the time of entering into an agreement if they are to be binding. Like for example, अब इस case में क्या है? You go to a shop and there's a sale, 50% off, but there's a small up to written. Now that means up to 50% off and on selected items. What is this? Exclusion clause. Is it signed? No, but it is there and you can't do anything about it.
And even you were telling me in some of one of our classes that it's also what was the term? Attracting, to attract customers and
That's a क्या था वो word? हाँ, even I forgot.
just for attracting the customers. So that is okay. You can do it.
Hmm.
Uh,
Think what was that word?
uh,
Invitation to treat.
yes, invitation to treat. So is it that you're talking about?
No, this is not invitation to treat. The 50%, yes, it is invitation to treat, but the exclusion clause, which is written very small terms and conditions apply, or up to, or on all stock, or on limited stock, that's small asterisk. That's exclusion clause. That's not invitation to treat. That bada 50% is invitation to treat. But the छोटा सा जो लिखा
Okay.
हुआ है नीचे वो that is exclusion clause.
Okay.
Okay. Next, onerous terms, please read.
When a term is particularly unusual and onerous, it should be highlighted. Although it is doubtful whether this applies to signed contracts, failure to do so may mean that it does not become incorporated into the contract. If there is something particular unusual, then it should be highlighted, just like the exclusion clause. You have to make sure everybody, the other person, can read it properly. But it is not that important, just like a signing contract. It shouldn't be like there are cases when it's not even signed. So that's it.
It is unusual and it is one-sided. Okay. You must highlight it. That's all we need to know. So next, interpretation of exclusion clause. Please read.
In deciding what an exclusion clause means, the court interprets an ambiguity against the party who relies on
Lies.
who relies on the exclusion. This is known as contra profundum rule. Liability can only be excluded or restricted by clear words.
ऑल राइट, अगर कोई पार्टी अपने एक्सक्लूजन क्लॉज पे रिलाई कर रही है, जैसे मैंने अभी आपको सिचुएशन बताया, द इंश्योरेंस कंपनी वाज रिलाइंग ऑन देयर एक्सक्लूजन क्लॉज दैट ओके कुछ हुआ हादसा तो हम ऐसे बच जाएंगे. ठीक है. इवन द डॉक्टर्स समटाइम्स दे रिलाई ऑन द एक्सक्लूजन क्लॉज की यार अच्छा कुछ नहीं भी मतलब कुछ गड़बड़ हो भी गई तो खैर है ना, एक्सक्लूजन क्लॉज तो है ना.
Mm.
They are relying on it, and when you rely on it, then that means there is
They're
contract.
actually using that term in their own favor.
Yes. Yes. Then, in the Hollier case, the court decided that as a matter of interpretation, the disclaimer of liability could be interpreted to apply. Disclaimer. Now, what doctors give us that disclaimer sheet. That's the term that I wanted to use. Disclaimer sheet, disclaimer of liability. Even we as auditors, when we go to the company, it may happen that we are, because we are experts in our field, we are going as an auditor and we are giving a we are making a report on the company, that this company is, the financial statements of this company is true and fair, and they are doing a good job, or they are, it's, they are, their financial statement is depicting the true picture of the company's status, right? And they are not involved in any kind of major money laundering or illegal matters, right? There is no manipulation. So who is giving the gawahi for that? Who is giving the, who is putting the stamp on that company? The auditor. So ऐसा तो नहीं होता ना कि ऑडिटर ने बिल्कुल 100% सारी चीजों का ऑडिट किया हुआ हो. Again, it's based on the experience. It's based on some of the tools and techniques we learn in
Exactly.
in the audit thing. And it might be possible that हमारी नजर से कोई चीज चूक गई हो और बाद में वो
Mhm.
कंपनी का बहुत बड़ा कोई ब्लंडर नजर आ गया हो और वो सामने आए.
Yeah.
ठीक है.
Not intention, okay, हमारे पास तो clause है, that's fine. Now just give me bribe and I'll do whatever you say because I have the clause with me. So the intention should not be there.
The intention should not be that. So in that case, जब हम इशू करते हैं और एज एन ऑडिटर हम रिपोर्ट इशू करते हैं एनुअल बुक्स में, तो क्या होता है, हम साथ में एक डिस्क्लेमर भी लगाते हैं कि to the best
Mhm.
of our knowledge, to the best of our expertise, to the best of
Mhm.
everything, we have done this. In case अगर बाद में कोई 6 महीने बाद, 7 महीने बाद कोई चीज सामने आती है, तो we are not
I'm not liable. Yeah.
responsible. ताकि ये एक डिस्क्लेमर चला जाए कि हमने अपने बेस्ट ऑफ नॉलेज से कर दिया, लेकिन फिर भी जाहिर है इंसान होने के नाते कोई कुछ भी हो सकता है. एंड द पीपल हु वांट टू हाइड समथिंग एंड दे आर स्मार्ट, they really are smart, they can do some many things
Yes.
to hide. Okay, so ये चीज हो जाती है. So that's a disclaimer of liability. Only to accidental fire damage, only to fire damage caused in any way including negligence. तो अब आप देख सकते हैं कि एक्सक्लूजन क्लॉज के टर्म्स बड़े मैटर करते हैं.
Mhm.
You can exclude some liability, you can exclude all the liability through that. And if both the parties have signed it, then they have signed it. But yes, the
Yeah.
government or the state or the court is there to protect the rights of the humans.
Yeah. And to judge the intentions.
Yeah. Now, the main purpose rule. What is the main purpose rule? Please read.
When constructing an exclusion clause, the court will also consider the main purpose rule. By this, the court presumed that the clause was not intended to prevent the main purpose of the contract.
Right.
It's the same thing that to get to know one person's intention, the court will look into it. What was the main purpose of making this this law? So after that, they can easily judge that what actually the intention was.
Okay. Now, the fundamental breach. There is no doubt that common law, a properly drafted exclusion clause can cover any breach of contract. Of course, अगर कोई breach होती है तो ये exclusion clause से आप बच नहीं सकते breach से, ठीक है? So you breach मतलब terms and conditions of contract के आपको fulfill करने ही होंगे, right? Next, the Unfair Contract Terms Act 1977 aims to protect parties when they enter contracts by stating that some exclusion clauses are void and considering whether others are reasonable or not. यानी कि अनफेयर कॉन्ट्रैक्ट टर्म्स एक्ट ये एक लॉ है, कानून है, जिसमें वो मतलब प्रोटेक्शन इस तरह से दी जाती है कि हर एक्सक्लूजन क्लॉज जो कॉन्ट्रैक्ट में लिखा गया है जरूरी नहीं कि वो वैलिड हो, वो वॉइड भी हो सकता है. और वो वॉइड किस बेसिस पे होगा? अगर उसको इंटरप्रेट सही से नहीं किया गया, अगर उसको इनकॉर्पोरेट सही से नहीं किया गया, मे बी अगर इंटेंशन गलत है. ओके, सो ऑल ऑफ
Mhm.
दैट. नेक्स्ट, सो
या
प्लीज.
मे बी वो ऐसी चीज पे इम्प्लीमेंट होता है जो कि लीगल नहीं है, या कोई जैसे वी वर टॉकिंग अबाउट के कोई ऐसा रिटार्टेड बंदे हों या इस तरह, तो दैट इज लाइक अ वॉइड कॉन्ट्रैक्ट, सो ऐसा कुछ.
So now this is this para, you need to go through it yourself. Okay, we have, so there would be clauses that are void and some would be subject to test of reasonableness. Of course, the clauses जो भी लिखे गए हैं या तो वो void declare हो जाएंगे या फिर उनको एक टेस्ट से गुजारा जाएगा ऑफ रीजनेबलनेस कि क्या वो रीजनेबल हैं भी या नहीं, जैसे कि इस केस में इंश्योरेंस कंपनी का आपको लग रहा है कि ये एक्सक्लूजन क्लॉज रीजनेबल है, जो अभी मैंने आपसे शेयर की स्टोरी, कि भाई एक्ट ऑफ गॉड में हम रिस्पॉन्सिबल नहीं है, हम लायबल नहीं है, हम इंश्योरेंस पंप के पैसे नहीं देंगे। भाई फिर फायदा इंश्योरेंस का, एक्ट ऑफ गॉड में तो फिर सारी चीजें आ गई, फ्लड आ गया,
एग्जैक्टली वो तो फिर आप किसी भी तरह आप जस्टिफाई कर लोगे एक्ट ऑफ गॉड को।
राइट। नाउ क्लॉसेस विच आर वॉइड, जो वॉइड है वो क्या है? A clause which purports to exclude or limit liability for death, personal injury resulting from negligence. This is the key circumstance to remember. यानी इस तरह का अगर क्लॉज है कि जो नेग्लिजेंस की वजह से आप बोल रहे हो कि भाई अगर डॉक्टर की लापरवाही हुई और डेथ हो गई तो भाई हम जिम्मेदार नहीं, ऐसे तो नहीं हो सकता ना, कहीं तो जिम्मेदारी डालनी
ट्रू।
पड़ेगी ना, नहीं तो फिर हर डॉक्टर
ट्रू।
शराब पी के पार्टी करके आके
इजी
सर्जरी।
हो जाएगा। हम्म।
In a contract for the sale or hire purchase of goods, a clause that purports to exclude the condition that the seller has a right to sell the goods. ठीक है, आप सेलर से उसका राइट नहीं छीन सकते गुड्स बेचने का, ऐसा कोई क्लॉज
हम्म।
नहीं आप डाल सकते।
हम्म।
नेक्स्ट, क्लॉजेस विच आर सब्जेक्ट टू अ टेस्ट ऑफ रीजनेबलनेस, यानी कि अब रीजनेबल है भी ये क्लॉज, यानी कैसे पता चलेगा? relative strength of the parties, whether any
हम्म।
inducement, whether customer knew or ought to have known, if failure comply with a condition, whether goods were made, processed or adapted to the special order of the customer. ये सारे पॉइंट्स हैं जो आप देखोगे तब आप डिसाइड करोगे, या कोर्ट देखेगा और फिर डिसाइड करेगा वेदर वो क्लॉज रीजनेबल था या नहीं। नंबर वन, स्ट्रेंथ ऑफ द पार्टीज, दोनों पार्टीज क्या बराबरी के हैं, या एक बड़ी बड़ी कमजोर पार्टी है, एक बड़ी मजबूत पार्टी है, ऐसा तो नहीं कि मजबूत पार्टी कमजोर पार्टी का फायदा उठा रही है। Next, whether any inducement, yani reduced price was offered to the customer to persuade them to accept limitation of their rights. कहीं
ओके।
जबरदस्ती बंदूक की नोक पे काम तो नहीं करवाया।
बंदूक तो नहीं, बट एट टाइम्स ये होता है कि वो हमें बोलते हैं कि ओके फाइन वील बी गिविंग यू सम डिस्काउंट, बट आफ्टर दिस डिस्काउंट यू वोंट, वी आर नॉट दैट मच लायबल।
Whether the customer knew or ought to have known of the existence and extent of the clause, क्या aware थी, दोनों
उसको डेप्थ का पता था।
डेप्थ का
ओके।
पता था या नहीं पता था। नंबर फोर, if failure to comply with a condition, failure to give notice of a defect within a short period excludes or restricts the customer rights, whether it was reasonable to expect when the contract was made that compliance with the condition would be practicable.
ओके।
उस प्रोडक्ट,
रियलिस्टिक गोल था या नहीं था, कुछ बिल्कुल भी वो एक्सपेक्ट कर रहा था, कोई बहुत बड़ी बात तो नहीं थी, कुछ ऐसा नहीं था।
हाँ, फेलियर टू कंप्लाई विद द कंडीशन यानी कि
जैसे फॉर एग्जांपल अब एक कार सीखते हैं तो एक रीजनेबल नॉर्मल बात है, बट अगर कोई मेडिसिन है ऑब्वियसली इसकी इंटेंसिटी ज्यादा है, तो वो फिर फेलियर टू कंडीशन, वो फिर एक इंटेंसिटी ज्यादा हो जाएगी चीज की, देन
इसको
ऑब्वियसली
हम
इट
इस
हैज टू
तरह भी
बी।
कह सकते हैं दैट फॉर एग्जांपल आई परचेज समथिंग फ्रॉम यू एंड I fail to notice that I have purchased an expired product. After maybe a month or so, I noticed that, oh my God, I've purchased an expired product. And then, of course, एक महीना गुजर गया तो अब एक्सचेंज भी नहीं होगा, कुछ भी नहीं होगा। तो अब ये तो एक कंडीशन ब्रेक हुआ ना, मगर अब कस्टमर का क्या राइट्स हैं इसमें, हम तो सोच भी नहीं सकते कि हमारे भी कोई राइट्स होंगे, मगर यूके में है राइट्स। टेस्ट ऑफ रीजनेबलनेस के एक्सक्लूजन क्लॉज कब तक वैलिड है, कितने दिन तक वैलिड है, कब तक प्रैक्टिसेबल है, नहीं प्रैक्टिसेबल है, क्या चीजें, कब होगा कब नहीं होगा, whether the goods were made, processed or adapted to the special order of the customer, क्या कस्टमर का स्पेशल ऑर्डर था जिस पर आपने ये बनाया है, क्या कस्टमर की डिमांड थी कि एक्सक्लूजन क्लॉज लगाया जाए।
ओके।
दैट इज स्टेट ऑफ कंज्यूमर राइट्स, provides protection for consumers in contracts with businesses, again क्यों, ताकि फेयर हो, ताकि उनको कोई, उनके राइट्स को कोई वो नहीं करे, फेयरनेस।
वैसे people are using misusing this law like anything. One of my friends, she lives in America, and she was telling me that what I do, I go to a market, I buy nice creams for me, foundations, and then I come back, I put it in a jar, and then return the half of the bottle back, and I tell them that I didn't like it. So people are misusing things like anything.
हर्ट कि भाई हम खरीदते हैं कपड़े, फिर एक दिन पहन लेते हैं, नेक्स्ट डे हम रिफंड करने चले जाते हैं। हम बोलते हैं रिफंड दो, ये
Right.
वापस, और वो ले लेते हैं। तो हम एक दिन
Mm.
पार्टी फिर वापस कर देते हैं अगले दिन।
True.
So that's okay, fine. Exemptions. Two types of terms are exempt from the rule on fairness. Number one, price, subject matter of the contract. These two are exempt. So this is a something to learn. Okay. Consumer reliance. Consumer may rely on a term which is deemed unfair. Unfair terms do not invalidate the whole contract, which will continue as far as possible. यानी अगर कोई टर्म अनफेयर है तो इसका मतलब ये नहीं कि पूरा कॉन्ट्रैक्ट ही आपने डस्टबिन में डाल दिया। वो एक टर्म
Mhm.
इनवैलिडेट हो जाएगा, दैट्स इट। बाकी पूरा कॉन्ट्रैक्ट आपको एज इट इज लेकर चलना है।
Okay.
ओके जी, यहाँ हमारा चैप्टर कंप्लीट होता है अल्हम्दुलिल्लाह। एनी क्वेश्चंस टू नाउ? बिजनेसेस एक्टिंग एज कंज्यूमर्स, जो कंज्यूमर बिजनेसेस होते हैं उनके लिए भी ये रूल्स अप्लाई होते हैं, लॉज हैं, कंज्यूमर राइट्स हैं। ठीक है, तो द सेम वे द एक्ट प्रोटेक्ट्स द बिजनेसेस एज वेल हु आर इन द रोल ऑफ अ कंज्यूमर। ऑल राइट, एनी क्वेश्चंस टिल हियर किंजल?
No, ma'am. Everything is clear.
ओके अल्हम्दुलिल्लाह, दैट्स ग्रेट। सो लेट अली, एनी क्वेश्चंस? प्लीज रिप्लाई। आज तो आप साइलेंट लिसनर बने रहे। ठीक है भाई, मुझे पता नहीं चलेगा। All right. So inshallah, tomorrow is what? Tomorrow would be Thursday. We shall
First day.
in the morning. We'll be starting inshallah on time, 11 a.m. Okay, inshallah.
Okay.
We
Okay,
have
ma'am.
done
Inshallah.
this. What is it? What is it? This chapter. Let me take it. This done. Content of contracts done. Two more left, and then we shall proceed. Okay. Till then, take
Okay, ma'am.
laugh. Have a good day.
You
Have a
too.
good night.
You too, ma'am. Thank you. Allah Hafiz.